What is a waiver of subrogation, and why do insurance companies charge a fee in order to provide them? Hello and welcome. I'm Brian Day with GSQ Insurance, and I get asked these questions a lot. So a waiver of subrogation is essentially when you waive your rights and your insurance company's rights to recover damages from a third party. Sounds kind of chicken, doesn't it? Well, it can be. And these are typically a result of a contract. In fact, just about any contract that your business enters into is likely to have a requirement for a waiver. We see these in lease agreements, construction contracts, vendor and even subcontractor agreements, as well as consultant contracts. So, what you're doing is you're waiving your right to recover damages from another party. So let's use the example of a lease agreement. In a lease agreement, it might not be uncommon to have the property manager or property owner, whoever you're signing the lease with, have you waive your rights to subrogation, both on your liability and your workers' comp. So what does this do to you? Well, say you lease the space and one of your employees gets injured while they're at work. They trip over a large crack in the sidewalk, or maybe it's a pothole in the parking lot. These items are typically the responsibility of the property owner and the property manager to maintain. So while your workers' compensation insurance company will likely pay for all of the injuries, the lost time, and medical bills of your employee, they at this point have no legal right to go back to the property manager or the property owner's insurance policy to recover those damages that they've paid. This is why they charge a small fee. They know that they are basically accepting another potential risk that they have no rights to recover. There's also a mutual waiver of subrogation, which if you're going to get stuck with a waiver, at least make sure it's mutual, which means that neither party can sue each other. In the case of the same location that you lease, what if there's a fire in the building? It's a multi-tenant building. Well, the investigation determines that the fire started in your space. So guess what? With that mutual waiver in place, the property manager can no longer sue you for the fire that started in your suite. Now, your insurance policy is likely going to put it back together anyways. But there's something important to note out here with all these waivers and can't sue each other. There's no contract that I'm aware of between neighboring tenants that would require neighboring tenants to waive each other's rights of subrogation. So keep that in mind. If you're next to a high volume retailer, maybe a jeweler or someone who has hundreds of thousands, if not millions of dollars in inventory, and you burn their suite down as well, well, guess what? They do have the right to subrogate, and your liability limits better be enough to help put their suite back in order. Otherwise, that will be hanging over your head. So I hope this makes a little bit of sense. I do think that in many instances they are overused, and they are a little on the chicken side. I mean, let's be honest. If you're responsible for someone else's injury or someone else's incident, well, shouldn't they have the opportunity to collect those damages from you in some fashion? You let me know what you think. I hope you enjoyed. Stay tuned. Next week, we're going to dive deeper into this topic when it comes to third-party action over claims, which is when a waiver of subrogation, a hold harmless agreement, and an indemnification agreement turn a lawsuit from a third party onto you. It's a lot of fun. So until then, have a safe week. Have a great week.